Our next case is Seligman versus Oasis Master Association. Okey-doke, Ms. Appellant, you're up.
Thank you, Your Honors, and may it please the court. Deneen Waslick, appearing on behalf of appellants Mark and Jan Seligman. I would like to reserve 5 minutes for rebuttal if I could. In this case, Your Honors, we think that the trial court made an error in granting summary judgment, and in fact, this court should reverse and remand either for entry of judgment for my clients or at the very least for a trial for several reasons. The most pressing is the fact that the trial court misunderstood its ability to determine the applicability of the statute of limitations and laches defenses on a motion for declaratory judgment, and the factual bases for those defenses support summary judgment in my client's favor. And then secondarily, if
trying to get
court,
us to opine and weigh in on the meaning of the restriction 21.8. Is that what you're asking for? Is that the relief you want?
I'm sorry, I didn't hear you, Judge Black. Can you repeat that?
You're not terribly loud there, Judge Black.
Thank you. Section 21.8 of the restriction. Are you here seeking an interpretation from this court as to what that means?
Yeah, alternatively, Your Honor, yes, we think that the court can interpret the public nudity definition in the declaration and find in my client's favor that public nudity.
You're taking the position that public does not apply to your client, right?
Correct, Your Honor. For several reasons. The main one being that the behavior that led to this lawsuit by my clients is being naked in their own backyard in a community that is intended for nudity in your public yard. The restriction on public nudity in the declaration has to be read in the context of the fact that this is a nudist community, that everybody understood that this is a nudist community, and most importantly, the declarations require that the parties be members of the nudist association, which has rules on what is considered public and private nudity. And we think that those rules about public and private nudity are very relevant.
Well, there's no definition in this declaration of public or private nudity, is there?
There is no outright definition, Your Honor, but I think that the principles of statutory and contractual interpretation, which
let me come back. Your client, Dr. Seligman, at one point had been quoted as saying that in this community you can be nude in the front yard. Not nude in the front yard and nude in the backyard, correct?
Right, and that's all he wants
and
to do.
What is there in the declaration that supports that view?
The notion that in the front yard you're potentially in public, but in your backyard you're on your own private property. We think that
aren't you in your own private property in the front yard?
But you're potentially on the street, and I think that the understanding of public and private nudity has to be interpreted in the context of the association definitions that everybody who is a member of this community is required to join the association for the Public Nudity Association, the Nudist Association. And that makes very clear that public versus private has to do with where you are, not what you can see. And so we think that that makes very clear that the backyard is not public for the purposes of these declarations. I think also it's important to look at the fact that the HOA, there's evidence in the record, the HOA has since tried to amend the declaration to state that public refers to, visible from other areas. And that just goes to show that it didn't mean that beforehand, because if it did, then they wouldn't have to amend it to make it, quote, clear.
Well, maybe they just don't want to get into any more litigation about it.
Sure,
I mean,
absolutely.
It's a good idea maybe to clarify that. But let me come back to, what your first statement today about this case being about the judge's misunderstanding of her ability to apply statute of limitations and latches in this case. Now, your client's suit was sought an affirmative relief based on statute of limitation and latches, correct?
Yes, my client sought a
So
declaratory judgment.
when did your client's cause of action accrue?
My client's cause of action accrued when they received a letter threatening that they were going to be sued and that the association was going to be seeking attorney's fees and other things against them and filing suit if they don't comply with that letter. That is the actual controversy.
But your lawsuit, your latches claim doesn't claim that the association lost its right by virtue of that letter.
The lawsuit says the association lost its right by only sending that letter for the first time very recently, I believe in 2019, when my clients have been nude on their property since they purchased it, since this community.
We've lost your sound, Ms. Wasilek.
Can you hear me now?
Yes.
I apologize, Your Honor. The latches issue,
well, couldn't that letter have said, gee, you had the right to sue us claiming latches, but you haven't, and therefore you need to stop. I mean, if you're using, because so far I haven't found a case, and you haven't cited one, where you can sue someone and say, you are prohibited by latches from enforcing some right against me. Couldn't they have said you're guilty of latches for failing to bring that suit years ago?
The difference is that the latches is a defense to what they were claiming they were going to sue my clients on. And so once they
your sound is gone again, Ms. Wasilek.
Can you hear me now?
Yeah, it's just kind of popping in and out.
Sorry. Once they raise the actual
again.
Can't hear
for
you.
that, can I call? Can I use the phone to call? Can you pause and so I can call?
Sure. I'll stop your time.
Thank you. I was joined by telephone, but I need to be.
Your sound just cut out again.
Judge Northcutt, we are going to unmute her and ask her to speak.
Okay.
She's muted.
Can you hear me now, Your Honor?
Yes.
Okay, I apologize. I have the sound on my phone and the video here. So
I get it.
and I also apologize. I think Can you repeat the question where we left off?
I don't know what my question was, frankly, but it occurred to me to say, why, how come the association couldn't say, well, we sent that letter because you should have sued us and claimed latches and statute of limitations years ago. So having done that, we relied on our belief that you weren't going to claim that. I mean, you see where you get into kind of a loop when you use latches and statute of limitations as an affirmative, as a basis for affirmative relief?
Well, Your Honor, I think the difference is that my clients were in a position to rely on the fact that they were able to do the behavior that is now suddenly being told that no longer is compliant for many, many, many years. And when they got a letter saying that they were going to be sued based upon this activity, that created the cause of action to ask the court to relieve us from the insecurity. I think there's no question that if they had actually been sued, they could say, latches bars that suit. And I think there is really no difference here when the threat of the suit is real. All of the cases cited by the other side about, not being able to do a court advisory opinion are cases where there was a settlement or, or they.
What I'm saying is why can't, what I'm saying is that if there is such a thing as using latches, for instance, as a sword to seek affirmative relief, why couldn't the association say, we sent that letter in reliance on the fact that you never claimed that we were barred by latches when according to you, you could have done that years ago?
Sure. No, I don't think that we could have filed suit years ago because we didn't know there was a controversy because of latches. The very nature of latches is that someone has not asserted a right that they have for so many years that my clients relied on it. They had no reason to file declaratory judgment.
Come up if you were sued, then you could say, well, wait a second.
I'm sorry.
My clients have been nude in their backyard for 15 years and you didn't do anything about it. It's like you're asserting an anticipatory argument of latches, but nothing's been enforced that would allow you to do that. Nothing's been affirmatively brought against you.
I think, Your Honor, the difference is here that there has been an affirmative
aren't you
threat
kind of
of
saying,
suit.
if you, we realize you haven't sued us, but if you do, we're gonna raise the defense of latches because you should have done this years ago and you didn't. And my clients have been using their backyard, nudity in the backyard for a decade or more.
Right, Your Honor, but I think in this case, what gives rise to the cause of action for declaratory judgment is the letter threatening suit after many, many years of not raising this issue. And so that is when the latches defense arises.
Well,
I don't think that the association could raise latches because there's no reason for us to sue because they did not say they were going to enforce. But now that they've sent an affirmative letter saying we are going to sue you if you don't stop this action, my clients are entitled to a declaratory judgment to relieve them from the insecurity of determining whether or not.
But on the merits of that, then, before the lawsuit was filed, the association sent, I don't recall whether it was an email or newsletter message or whatever, but basically announced to the community that these rules were going to be enforced, correct?
Yes, they did. I think that that alone is not enough to raise the specter of a declaratory judgment. But well, the
question then must arise whether your client validly could continue to rely, assuming your clients could rely before, but could continue to rely on a belief that the association was not going to enforce those rules.
First of all, yes, I think so, because there was no threat of imminent suit. And second
your clients knew though that or surmised that this message related to them.
Maybe, and they were having conversations.
Well, I think that they acknowledged that.
The period of time was between when that email was sent and when the letter saying, yes, we're going to sue you. Now you have it. And so we filed the declaratory judgment is so short that I don't think the latches would apply there. I think that, you know, on your theory, Your Honor, that the latches would set in, the latches would set in at that point when it said, yes, we're going to start.
No, I'm talking about,
So recently.
I'm talking about your theory that latches prevented the association from having announced that they were going to henceforth, at least, enforce these rules. How could your client then claim reliance?
Because they're relying on 20 years worth of action, and you know, as soon as they got the letter, they tried to clarify. They reached out, they had discussions, and all of that culminated in the letter from the HOA saying, we are going to sue you, we are going to seek attorney's fees and damages. And at that point, the declaratory judgment cause of action was ripe, and they were entitled to relief from that insecurity about, you know, whether or not the laches would prevent it, because without the ability to get that affirmative action, they just have to sit there and wait and see whether or not they're going to be sued, and in the meantime have much uncertainty about whether or not they can continue to do what they've been doing for 20 years. And I think that is the importance of, you know, especially the laches defense, is that, you know, when you relied on something for a long time, and this reliance, by the way, is, you know, very much supported by the facts in the case, including the fact that, you know, the people who were involved from the very beginning knew that the Seligmans were nude in their backyard, and that they could be seen from the street from their backyard from the very beginning, and that they did not do anything about it until suddenly, very recently.
Well, I think pretty clearly,
you know, that knowledge
clearly at the very beginning, the developers understood that the Seligmans wanted to be nude in their backyard. And that's why they had the discussion about the extra viburnum bushes and whatnot. And the reason she wanted the 1 acre property so she could garden naked, they all knew that.
Yes,
And
absolutely,
she has been.
Your Honor, exactly. And that, yes, and that has been acknowledged by the HOA from the beginning. And so from the day they signed the contract to build the house, there was always an expectation that they would be able to be nude in their own backyard in this nudist community. You know,
But the developers representative, I recognize are, you know, this might create fact issue. The developers representative denied that, correct?
You know, there's
Admitted an
some
affidavit.
denial, but there's also some acknowledgement. Yes.
Well, acknowledge that they built the hedge. Yeah. We've helped you reach the rebuttal time, Ms. Waslick. You can proceed.
Okay.
As you wish.
I'll reserve for the rebuttal then. Thank you, Your Honor. I appreciate your patience with the technical difficulties.
Oh, no problem. We've had our own before you. Okay, Ms. Sabona.
Good morning. May it please the court. Teresa Sabona on behalf of the Oasis Master Association. I want to touch on briefly something that Judge Black started with, which is the enforcement of the provision, paragraph 21.8. This is a claim. This case is all based on a 1-count declaratory relief based on that provision of the declaration. The Seligmans argue that these other defenses, statute of limitations and latches, that these are in some ways defenses in their own declaratory action. And as Judge Black noted, that in some ways is an anticipatory defense to a potential litigation, a future litigation that may or may not occur by the association. Now, if the Seligmans intend to or want to raise those defenses, should there be a future litigation, they're certainly entitled to, under Florida law, to raise those affirmative defenses. However, these defenses should not be applied in a declaratory action such as this, where they're being used essentially to be a defense to a potential litigation that has not occurred. I also want to touch on
the only issue currently before us is the interpretation of 21.8, isn't that right? That's the only issue raised in the complaint.
Correct. It is a 1-count complaint for declaratory relief pursuant to paragraph 21.8 of the declaration.
More specifically, the issue boils down to what is the meaning of public nudity?
That's correct, Your Honor.
That's it, right? That's what's on the table.
That's correct, Your Honor. And that provision specifically discusses where nudity is allowed in this community and where nudity is prohibited. Now, there's been discussion about this community and that it's a nudist community. But what's important and that what's been acknowledged by the Seligmans throughout this litigation, both below and on appeal, is that this is a hybrid community. And that is indicated also in the complaint at page 81. The declaration, specifically to paragraph 21.8, says public nudity shall be allowed within the club area. That's where it's allowed. It then says public nudity shall not be allowed or visible outside the club area. So paragraph 21.8 discusses areas that it's allowed within the community and areas where it's not allowed. Judge Northcote mentioned the affidavit of the developer, Michael Benjamin, that was provided with the association's motion for summary judgment. And that affidavit specifically indicates that it's not the intent for nudity to be anywhere and everywhere within this community. That is what makes it special, is that this is where if any passerbys or anyone within the community, if they are driving through, they wouldn't know. And that's because it is not to be visible outside of the club area. It is not to be allowed outside of the club area. So that is the declaration, that is the provision.
I can see how public nudity might be interpreted differently, but it's broader than that. That if you're standing in your own backyard and you've got a hedge all around it, that would seem to fall within the acceptable parameters of this provision.
Potentially.
How is that public nudity?
It's potentially public nudity if it's visible, and that's what is focusing on, is where this is visible. Now, the other thing,
and this paragraph in the declaration mentions visible, like
correct,
not
correct.
be allowed or visible outside the club area.
That is correct, Your Honor. And so even
because
if
private nudity that is visible, kind of sort of as implied and at least implied in this passage, becomes public, does it not?
correct, and that I think is what the declaration specifically says is, and I quote, public nudity shall not be allowed or visible outside of the club area.
But if there's sufficient hedgerows and whatnot, then that would seem to be within that would be okay within this definition.
If the nudity was not visible,
I guess what I'm saying is I don't read this provision as being per se you can or cannot be naked in your backyard. You might maybe yes, maybe no, depending on what you're doing to conceal yourself. Is that right?
I would agree with that, Judge
Yeah,
Black.
and other homes in the development have privacy fences, correct?
That's correct. So the other homes, there's 28 home sites within this community, and many of the other homes, and I believe most of the other homes do have these privacy fences. And going back to Judge Black's concern, I think if there is a hedge that would obstruct the view of someone's backyard, then they could be nude within their backyard. The issue that I believe led to the April 2019, the letter that was provided to the Seligmans, is the fact that people saw the Seligmans nude in their backyard. That's the concern. So even though there was landscaping in the backyard, clearly the landscaping was not of a sufficient way to obstruct the view from the lane that abutted the property, that the Seligman's property. I think the other thing that's important to note is that this is a declaration for a homeowners association. The Seligmans, Mr. Seligman put in his affidavit, he attested that he received the declaration prior to purchasing the lot. They purchased the lot in 2003. They had the declaration, but pursuant to the purchasing agreement, they had to have been aware and agreed to abide by the declaration. The declaration is a contract. These are covenants that run with their land. There is no question that there is a contract. There is no question that they are bound by the declaration. And to support the Seligman's analysis that, well, public means something outside of the association, that it's something broader than that, that would gut the declaration. That would gut contract principles for HOAs and condos and associations, because this is what binds them. So they've agreed in the purchase agreement that they would be bound by this. The declaration itself says they must be bound by this. And so for purposes of this paragraph, that as long as they are visible, then that's where the declaration provision comes in. And of course, I should also add that the declaration cannot be interpreted to provide an absurd result and to apply the provision and the argument that the settlements are offering, which is public, is something broader than the association, that would lead to an absurd result. I also do want to touch on the handwritten addendum that was in the purchase agreement that I know was brought up when my colleague was presenting her argument. The handwritten addendum makes no reference to nudity in the backyard. The handwritten addendum makes no reference to it being an amendment to the declaration. And in fact, the declaration can only be amended by 2/3 vote of the owners. Instead, the handwritten addendum was only to provide additional landscaping. And that handwritten addendum was by Michael Benjamin, who provided the affidavit in support of our motion for summary judgment. And Mr. Benjamin, again, clarified any concern. He said this landscaping was not to allow the Seligmans to be the only ones that can be visible in their backyard, to be nude in their backyard and be visible. But this was to prevent, to add additional privacy because there was lights from the cars on the passing by road. And that was the agreement. And that's why there was additional landscaping that was added. In sum, I do not believe that the declaration is unclear. I believe that the declaration is very clear that there are certain areas that nudity is allowed in this community. There are certain areas that nudity is prohibited. And one of those areas would be anywhere that is visible outside of the club area, which would include the Seligman's backyard. Unless there are...
Would you agree that the Seligmans could satisfy the requirements if they had more comprehensive shrubbery or whatever, that we aren't going forward, are we left with a per se rule that you cannot have nudity in your backyard, period, end of discussion? Or is it you may practice nudity in your backyard as long as you have enough shrubbery around?
I think the language of the declaration clears that up, Judge Black. I think it as long as it is not visible outside of the club area, you are allowed to be naked in your backyard in this community. And I think that is what the concern is, because the Seligmans did not have a privacy fence, which I believe every other home site or many of the other home sites did have. But instead they had more of a, I'll say, natural barrier. But over time, this hedge that they had was cut down for different reasons. And the landscaping, some of the landscaping was removed. So if there was a natural landscaping way by hedge or some other type of vegetation that would prevent visibility of someone's nudity in their backyard to other passerbys, I think that would comply with the declaration. So it's not that you can't be nude in your backyard. It's you can't be nude if it is visible to others.
And the court below did not grant affirmative relief to the
That's
association on that point. It just denied the relief sought by the Seligmans.
Yes, Your Honor, that is correct. That is correct. Unless this court has further questions, I would like to briefly conclude. In some, the Seligmans knew that the declaration was in existence and knew of the requirements prior to purchasing their lot. Pursuant to the purchasing agreement, they were aware they had to be bound by those restrictions. There is no question the declaration was a contract between the Seligmans and the association. There is no question that the association is a hybrid nudist community that allows visible nudity in certain areas and prohibits visible nudity in others. And that is what makes the association special. And to the extent that any of the American Association of Nude Recreation Bill of Rights concern, nothing in the declaration indicates that those Bill of Rights would supersede the declaration. Nothing in the declaration indicates that those Bill of Rights would serve as a definition for areas not defined in the declaration. And so for these reasons, and those previously set forth in our answer brief, we would respectfully request this court affirm.
Thank you, Ms. Savona. Ms. Waslick, you're up to rebut.
Thank you, Your Honors. I want to address a few things. I'll start with the Benjamin Declaration. I think that there's two issues with that. First of all, his statement about what his intent was is not superseded by the actual declaration. First of all, and more importantly, by the actions in all of the years since. And the actions in all the years since makes clear that both Michael Benjamin and many other representatives of the association had full knowledge over the course of many, many years that my clients were nude in their backyard, visible to the street, and it was never enforced or raised as an issue. Even when there was hedges there, they were several times, cut back to the ground and regrew, and there was never any attempt to enforce prior to that. And so we think the laches, there's at the very least issues of fact regarding the laches that require a trial. The trial court basically took the issue of intent at face value by his statement without any regard to looking at him in the eye and seeing, whether he is, and having him subjected to cross-examination, and also, seeing if he's truthful or not. So we think that there should at the very least have been a trial to determine, both that issue of intent and then more generally, the overarching knowledge of the laches issue. Secondly, I think that we're not arguing that the Nudist Bill of Rights supersedes the declarations. We're arguing that because people are required by those very same declarations to become a member of this organization, that informs the meaning of the words that are in the declaration as far as what constitutes public nudity and what is not nudity. And the declaration is very clear that people should be allowed to enjoy nudity within their homes and on private property. That's in the record at 307. And so my clients, the current mode of enforcement would not allow my clients to even be nude within their home, which is, very clearly, because if it can possibly be seen by the road, then suddenly it is not allowed, even though they are on their own private property within their four walls. And so for that reason, also, the declaration needs to be interpreted in accordance with the Nudist Bill of Rights. And then finally, I would add, I just want to follow up something you had said, Judge Northcutt, about the notion that they could have just, they should have waited, that laches would start running against my clients if the HOA had tried to enforce by letter, but then never actually filed the suit. And that's exactly the reason why my clients should be allowed to raise laches affirmatively at this moment in time, because otherwise the HOA would be in a position to just simply manipulate it by saying, now we put you on notice and you can no longer rely on the past 20 years.
Well, there's actually case law. There's actually case law that says, once an association warns everyone that it's about to enforce, it can enforce even though it didn't before. That's why I brought that up.
Yes, but I think that in this situation, there.
I mean, your claim of
not...
laches cannot delete a requirement of the declaration. It just can't. That's what I'm saying.
We're not saying it's deleting it. We're saying it's that it can't be. They can't interpret it one way for 20 years and interpret it and then change their interpretation of it now to the detriment of my clients, Your Honor. And so, unless the court has any other questions, I will just stand on our briefing and say that the court should, at the very least, reverse and remand for a trial on the factual issues regarding the laches and the other affirmative defenses here, or in the alternative, we think that our motion for summary judgment was strong enough that would allow for entry of judgment in my client's favor. Thank you.
Thank you both very much. I just wanted to ask one clarifying question I read in the brief. At some point in the brief, it said the viburnum hedge attracted alligators. Does viburnum attract alligators? I was unaware.
I don't know, Your Honor.
I'm going to keep that in mind.
I think it was a hiding place for the alligators. I'm not saying that it's like a pheromone or something.
Okay.
But the fact is that alligators hid them there, and they were seen from the street and by our clients as potentially threatening the people who were working near that, including the HOA's own workers that were doing, yard work. And so there was a concern for the safety of both my clients and the people around them with those hedges there for that reason.
Okay, great. In order to leave our virtual courtroom, you should click the button on the Zoom screen called Leave.